Got this manuscript, and it's got a complete and full account of this William Penn and William Mead case at the Old Bailey, which is the case that is given like a memorial on the plaque in the Old Bailey. It's the case that Extinction Rebellion and Tim Crossland are going on about at the moment, and they're actually sitting outside courts holding these signs up. I'm guessing that Crossland probably has read this account, but he doesn't really talk about it or go into any detail, and neither does anyone else. I don't know if he's read this actual complete, comprehensive, full account or not. He probably has, but if he hasn't, and if he's only read some of the general websites that reiterate it or give shorter accounts of it, there's quite a lot of very, very important and interesting information left out, which I think is absolutely critical. This case is... The reason this case is so significant is that it involves multiple aspects which are relevant to explain the surrounding facts and circumstances, very similar to the John Baswick and Henry Burton cases from the 1640s before the Civil War, just leading into it, because they involve the Court of High Commission, the Religious Court, the appealing to the Star Chamber, and also petitioning for release of prisoners to the House of Commons, and matters, quite a lot of things that are on that Bill of Rights to do with religious issues, to do with government law and petitioning rights and so forth, freedom of speech. So these cases, these are actually well documented, well cited cases, and they are for a reason. I mean, they could probably have picked out, dozens of cases for examples of petitioning, but I think these ones, I've actually realised that these are actually using some of these processes, and they've got multiple aspects to them which are notable for study. So I thought I'd read it to you. Now, I have actually read this, but each time I read it, I kind of like more and more and more sort of like is significant. I just wanted to say that, so when we start this, I want to start by saying that in the Magna Carta and the Petition of Right, the 1627 Petition of Right, and in the Magna Carta, the 4 clauses of Magna Carta which are still in force of what the legal process is founded on is that you can only be fined or have a legal action against you with prosecutions and so forth through a lawful process established in law, and either on a legal points of law or by the judgment of your peers. Now, it doesn't say a jury. It says by the opinion of their peers, right? The judgment of their peers, or by the rule of law. And I now believe that peers, but through a lawful process, doesn't have to be a selected jury. And it's quite clear now when I'm reading the Tumultuous Petitioning Act 1661, before we go into this William Penn and William Mead case at the Old Bailey, I just want to say that this case is in between. It's important to note that this case is in between the Tumultuous Petitioning Act and the 1688 Bill of Rights. In fact, this case probably, from what is revealed in this case, in the dialogue, and the fact that there's a plaque on the Old Bailey, some of the things that are said in these proceedings, I think, go on to have a role in the making of the 1688 Bill of Rights and the right to petition. So I think that the Magna Carta definitely is prominent, and I knew that that case with the jurors and the right of the jury, I knew that Magna Carta was important because some people have put the wrong words in when the government don't have the original on their website, and you've got to check other websites, but the wording is meant to be or judgment of peers. Sometimes it's recorded as being and lawful by rule of law and judgment of peers, which means both together, but it's actually or, so it can be either or, and that's critically important. Now, I was correct when we read this when we read this account of the William Penn and William Mead cases. They are speaking out about Magna Carta. They talk about it in the proceedings. They mention and recite it. And Penn and Mead are actually well versed in law. They're not just like, serfs or peasants or whatever. They're actually well versed in law. That's clear. They know their rights and so forth. And there's quite a few other important things that are said and mentioned in this account that reveal and confirm points of law, aspects, things like that are going on and happening. It's all the surrounding circumstances and surrounding legislation and the legal situation around the whole thing. So what I want to say to start with, I just want to go over the Tumultuous Petitioning Act because getting clarification on that act word for word and what it means is quite important. And every time I read it, I'm like, I've missed like the importance of one word or another word out. So I've just written down some notes, and I just want to go through the Tumultuous Act so we need to set out this act before we read William Penn and William Mead, because they're actually using this act in that case. So the trial of William Penn and William Mead at the Old Bailey, which is a central criminal court, which is equal to the Crown Court now, but it was the assizes, for a tumultuous assembly, right? And the case was the 1st, 3rd, 4th and 5th of September 1670. So it took place over 4 or 5 days. Wrote by themselves, but it's got this is like from the recorder, like the court recorder's records. It uses personal accounts and it uses the recorder's dialogue as well. So we'll just go back to the Tumultuous Petitioning Act at the moment now, right? Now, so the Tumultuous Petitioning Act, we've definitely got legal proceedings, and we've definitely got they've definitely got this whole basis already of a jury is meant to have protection in law. A jury is meant to have protection in law already, and witnesses and the sheriffs and so forth, but also if you're bringing a case. So now, with the Tumultuous Act, it does mention people who have gotten into power. Now, I believe when you read it, they're getting into power because they're doing petitioning, right? Because it's petition of right. So we haven't got the 1688 Bill of Rights at this time, but they are it's acknowledging that people are making use of petitioning to get into power or to get laws changed, but to also use the process, and sometimes with large numbers of people, right? And they're blaming that on the Civil War as well, that it was the cause of the Civil War. So right. So the things that the Tumultuous Petitioning Act applies to, they're actually they're grouping in, right, with petitioning. They're also including, right, remonstrances, which is kind of like making a point or a protest in public, making a point about a complaint or grievance in public. So for remonstrances, I guess Extinction Rebellion and Just Stop Oil, that I guess in a way they are making public remonstrances in their current actions. They might not be petitions, but they might be public remonstrances, right? So that's something that I've learned. It also includes complaints, petitions, disorderly soliciting of the procuring of hands, so getting signatures or other the procuring of hands, but also includes like by word of mouth supporting as well. Declarations and other addresses, right? But it's specifically concerning. So we've got all those things, but it most definitely concerns addresses to the King or the House of Commons or the House of Lords, either House of Parliament, right? So it's not concerning actually petitions to the council, unless you want to figure in, you might want to figure in it, like if it's a local council, it is the King, because it's got the King's, the mace, you know? If you think a local council or local courts also are included, you know, it could be the King as well. But there are some words in this William Penn and William Mead that kind of gesture towards that as well. But in the actual dialogue, which we can go through in a minute. So it's to the King or both or either Houses of Parliament. But we don't. So one thing I'm not sure on is if it also means the local council as well, and the local courts, or just because you know, if that is like, you know, a point of contact with, you know, the King through various, you know, departments and courts. But I'm going to go on the interpretation for just the King and Parliament at the moment, as it's set out quite simply, right? But so actually doing the petition and getting signatures. So this 1661 Act definitely it reveals this consent, and I think this consent word is important. The word consent of the peers, right? So the 1661 Act is acknowledging that you're getting consent when you're doing petitioning, and they're not too keen on the fact that you're actually getting this consent, right? So people are getting the consent through the signatures, and they're getting power by it, right? So because they're pursuing things to the Parliament or the King or either Houses of Parliament for alteration in matters of law. Well, you can't get the law changed by the local council, can you? The council can't make alteration in matters of law. Redress of grievances, matters of in the church and religion, or the state, or other public concernments. So you don't have, this is the thing about the petitions committee at the moment. They're claiming that you can only do things about getting the law changed, right? Not just bring like a grievance you've got with the government, which, you know, is a complaint. They've got departments for complaints. The thing is, they're actually including declarations, general complaints, as well as petitions and other addresses in with all these. Now, currently, the government likes to divide everything up. Like, if you've got a complaint about a councillor or a grievance about a councillor, you put it into the monitoring officer, right? But you can still do it, right? But for the Parliament or either houses of Parliament, it's meant to be a higher avenue of appeal from all lower avenues of appeal. And it's meant to be either Houses of Parliament or the King is meant to be, so or, if you don't get a matter sorted out by, complaining to, whichever department or person, you're meant to have a right of appeal to the King or Parliament, right, in law. So I think the petitions committee, by claiming that they're not having petitions about public concernments, just general public concern about something or other, or matters of state or church, they're usually now just arguing whether it's about the change in legislation, which you can actually have, like, a petition for a public inquiry. That's a public concernment. So there are this. So the Act also, one of the reasons why they've got the Act is because of violations of the public peace. So the king and government are basically concerned that they're using petitioning to use it as a violation of public peace, which I guess that's where they are now, really, with Just Stop Oil and Extinction Rebellion, and possibly even these Stop ULEZ campaigns. They're saying it's a violation of the public peace, and they have got into power. They've got this power and ability to do a violation of public peace because of the petitioning. Now, this is before the right to petition, 1688 Bill of Rights, so it still exists, and they're acknowledging that I think that this is my argument. I think that they're acknowledging that they're getting the consent, which is getting them into power of petitioning, by getting people to put their hands to it or agree to it or sign. And this is therefore what I think they were getting annoyed because they don't think it's a lawful process anymore all the time. So, and the thing with Magna Carta, it says by a lawful due process, right? So I think that when they're getting to all these loads and loads of numbers of people, that it's no longer like a lawful due process anymore. It's kind of like rowdy or rebellious or a violation of the public peace, right? But then what I don't think they're doing in the Tumultuous Act is saying that, the right of petitioning is not already existent, and in law it is legal and it is a lawful process of law already. And I definitely think at this point the signatures are regarded as the judgment of the peers, because it doesn't say a jury in Magna Carta. It says lawful judgment of peers. Now, the thing with the peers is this, right? The peers cannot make an alteration of law, right? The peers can't change the law or get the law changed, right? Or make law. Only Parliament can make law. So, I mean, private persons and people supporting petitions, they don't change the law, right? But they're allowed to make a case for the law getting changed, or make a criminal charge or bring a civil case, right? And so when the peers are what I'm definitely quite certain now is that a couple of people knocking around getting consent from their peers in bringing a civil or a criminal or even a petition case I don't think they're too bothered about it when it's just like one or a few people, but when you start getting large numbers of people, then it gets a violation of public peace, right? But they've definitely got a legal right, and I think that it definitely does give them this protection. I do think that at this point the protection is recognised because they're acknowledging the protection of the jury, at least in the Penn and Mead case, which we'll go into in a bit when I finish this bit, right? And I think that consent is by the getting of hands to it. And I know that it's not like a selected jury of 12 people, but for these petition cases, you're see. Now, the thing is, the more and more people you've got, the stronger and stronger the evidence of public concern. You can base a case on facts, a strong case on facts, or you can have a lot of people who are concerned about it. So, so they set out that persons. So there's two parts to it, really. The first part is actually doing the petition. So if you have only got like 5 people, you can get their signatures and set out a petition, a case, and even present it to the king without any problem. You don't actually have to go through any courts. It's actually considered a lawful process by getting the signatures, right? You could even get 12 people to sign it. Now, the problem is that they don't want, if you're going to get more than 20 people to support it or sign it, you've got to go to a court, right? And it can be with 3 justices, a larger part of a grand jury, and actually a division of the county. So it is the 100 courts, but this is only for the first part, not the second part. So the hundreds courts, you can go to the hundreds courts to get the petition kind of sort of assist. I want to use the word like an assessment. It's kind of like an assessment, right? Or the assizes. If you're in London, it can be the mayor with the alderman, and now that is the setup I think they've got in this William and Mead case, because it is in London, right? But the thing is that they've got the mayor and the alderman actually in the assizes in the Old Bailey, so it's kind of like a combination of two, really. So if you are going to solicit, labour, procure, get the signing or any other ways of consent, which means you can have other means of consent, like verbal, right? Or even like like some people couldn't sign their name, so they just put a cross on it, right? Or, maybe they nod or something like that. Maybe everyone raised their hand. I mean, you could have everyone raise their hand, or you could have everyone say aye, or, or actually sign it. It doesn't matter how they agree to it. On a vote, maybe, if you've got a group of people. But you're not actually, so that the law was made that you cannot get any form of consent at all. No form of consent whatsoever if it's over 20 people in any way, shape or form. You cannot get more than 20 people, but if it's under 20 people, you can proceed with it, right? And it's a lawful process to collect signatures and do it, right? you cannot get anyone to consent to it unless you first get approval, right, from this either 3 justices or a larger part of a grand jury, or in the hundreds courts, or assizes, so they can assess it, and then they can give consent for you to get more signatures, right? And more people to support it, which is a large, stronger evidence, right? But obviously, if it's under that amount, you don't need to. Now, if you're going about getting large numbers of people to support it, then it's an offence, right? And that even includes procuring. This is even soliciting, disorderly soliciting. Now, at this point, before we go into the next section, I'll just point out. So the Old Bailey case, and I'm sure that a lot of people know this, but this video is for people who don't know this, right? That plaque on the Old Bailey, I didn't know, or when people are casually talking about that case with the plaque, the memorial plaque in the Old Bailey, no one that I've heard casually talking about it on any videos has just said, oh yeah, it was a prosecution brought through the Tumultuous Petitioning Act. It's it is one of the Tumultuous Petitioning Act prosecution cases, right? That's important. No one said that to me. It's just like they made out it was just some random, rowdy in the streets, and then it's all about the jury. It's all about the jury and the jury's rights. It's actually, that case is a Tumultuous Petitioning Act case, and a very important one. And the dialogue in it is, it is really, really, really important and critical. Like the whole dialogue, the entire dialogue of the whole proceedings is really, really important and revealing to the whole process. That's why it's an important case study, really. So Penn and Mead actually were accused, and they got to have were accused of soliciting. I think it was 300 people or something. They were saying up to 300 people in the streets, right? So they wouldn't necessarily have been having to do a petition, though. If they got accused of getting, declarations, remonstrances, complaints, and the procuring of hands of petitions, disorderly soliciting, so effectively getting people to officially subscribe or support an action that is to be addressed to the King or either of Houses of Parliament, right? So that is the offence of what they were accused of. And we'll go into the case, like I said, in a minute. Now, the second part of this, right? Now, the next part of it, so it's any matters to do with law, church, state, so is the presentation part, the delivery part, right? So if any person or persons is going to deliver or present any petitions, I guess you could deliver it yourself on a cart, but it's not only petitions, it's also any complaint. If you're going to deliver a complaint or a remonstrance or a declaration or other address, right? So for that, you're not allowed, and this is permanently set, right? This is permanently set. You can't have more than 10 people delivering a complaint, petition, remonstrance, declaration, or other address. And there's no change in that number allowed at this point. not more than 10 persons. And that's interesting because you would have thought that in this, I'm just looking at the jury setup they've got in this Mead and Penn case. They've got one. I think there's 12. I think there's 1, 2, 3, 4, 5, 6, 7, 8, 9, there's 12 people in the jury. So it's interesting that they set it at 10 people because that's less than that they were having in the jury, 12. So it's almost kind of like, just too short of a lynching mob or something. So if you having juries actually can make an order through a court, a legal order, but obviously, they don't have the authority to make and change law. Only Parliament can make and change law. But otherwise, a jury can make other orders through lower courts and law, civil and criminal. So they've got it set so you can have a jury of 12 people present a declaration, petition, complaint or case or other address. That would probably also be like an order, from a court to the king. So it's very, very interesting and a bit of a twist that you couldn't have a jury of 12 people from any court in England. It would be illegal for them permanently. You can't change this number to approach the king or either of the House of Parliament with any petition, complaint, remonstrance, declaration or other address, right? With 10 people, you couldn't, have a jury turning up saying, "Oh, we've made a criminal charge or something," or a civil order, and here's the paperwork for it, So you couldn't have 12 people, only 10. Now that offence, for every, I think what this offence is that if over 10 people are to deliver the petition or even an address, this is speaking as well. So if they actually make a remonstrance to Parliament or either Houses of Parliament, declaration, complaint, petition, or even address them over 10 people, that would have been an offence. So I guess they've got that outside Parliament now. They've got all this keep back from Parliament. When they've got all these big protests, to keep back from Parliament, kind of like that, really. Now, for for any people or any persons that are breaking that law, there's got to be 2 or more witnesses though in the court to prosecute this, by the way. But I don't think for the earlier part of it. So they get prosecuted, but it's by the King's Bench at the assizes or quarter sessions. But now that one doesn't say the county division, which would be equal to the magistrates' court now. Because you wouldn't be, the thing is, if you were presenting it to the king or delivering it somehow or addressing, well, I suppose the king could be walking around the country, couldn't he? He might be visiting somewhere. He could be visiting a county. He might not be in London. But mainly if it was the House of Commons or the House of Lords where you're presenting a petition to, or even giving an address to them, or remonstrance or something, right? That is to be prosecuted at the King's Bench, which, luckily you might be near the King's Bench if you're near Parliament or in London, at the assizes, which is the Old Bailey if you're in London, or at the quarter sessions, right? Which are the periodic meetings. I guess if the king was in your area, in Northumberland, and you approached him with a petition to give it to him, then I guess you would be breaking this law. I guess you would go to the assizes of, one of the ones in Northumberland or the quarter sessions, I would have thought, unless the King's Bench can, unless he can conjure up his various, mobile courts there and then, because they had that Court of Commission, they just had it when they wanted. No, but that offence is not, so that this offence is separate, and it's not the offence of which William Penn and William Mead were prosecuted with. That's just for the delivery, and this is 10 persons. Now, according to law, that act was still in place up to 1986. So that apparently was stopping more than 10 persons presenting petitions to Parliament right up till 1986, which is quite interesting, because I thought that the Parliament had to they messed around and changed laws about demonstrations outside Parliament to try and keep people back. But apparently, all the way up to 1986, until they revoked the Tumultuous Act, it was 10 persons, whether or not people might even not have known about that act. And I think that in 1967, so in 1967, with this Criminal Law Act, which has got the assisting offenders section in it as well, they changed the wording of these quarter sessions. Now, it says in the law that they changed court to quarter sessions, but that's wrong. I think on legislation.gov.uk there's an error, unless I've been reading it wrong, but it says, as far as I've ascertained, it says that in 1967 they're claiming that they changed the words from court to quarter session, but the Tumultuous Petitioning Act version that I've got claims that the original wording is quarter sessions. So it was changed from quarter sessions to courts. But the thing is, I don't know whether it matters or not, because after 1967, 68, 69, 70, 71, 4 years later, they end the quarter sessions, right? So they're claiming they changed it from courts to quarter sessions for only 4 years, but it was all courts. But it wasn't all courts, because I think the original wording, the only wording we've got for tumultuous is it was quarter sessions anyway. So if they changed it from quarter sessions to courts, whichever, it doesn't really matter, because that only lasted for 5 years, and then they apparently repealed the whole act when they created the Crown Prosecution Service. So the whole thing went, including having to go through these other courts. Now, the thing is, so I'm not really too concerned about that offence with presenting it to Parliament or presenting it to the King, the delivery of a petition, because that offence that is prosecuted at the King's Bench, assizes or quarter sessions, that doesn't really matter when you're actually just wanting to do a petition, right? To start one, right? Or to get some evidence to do one, or get people to support it. So therefore, and they're going to acknowledge that you are doing a petition, because that's why you're getting prosecuted at the King's Bench assizes or quarter sessions, because there's no question about it, but it's just going to be on a prosecution. It's an offence. It's a normal charge, a crime, right? But now these earlier proceedings that you're meant to have, right? These earlier proceedings that you're meant to have, they can be held at the hundreds courts, at the assizes, and with a grand jury, a major part of a grand jury, or 3 justices. So it can be the public assessing it, but this is a lawful due process. They're wanting you to go through a lawful due process. But if it's over 20 people, if you're getting evidence and doing a case, you don't have to have it assessed. You actually can you can get 20 signatures, which will be, as far as I can gather, will be peer judgment of the matter that you've drafted up, the legal matter you've drafted up. You will be getting power from these And in 20 is over 12. It's over the number of a jury. So I think that is the consent of your peers. So that protects you for the petition case in the same way that it protects a jury, at least. I think if you are actually bringing a grievance, bringing a soliciting the hands, procuring the hands to the petition, a complaint, remonstrance, declaration, or other address to the King or Irish Houses of Parliament, I think that those 20 signatures, or 12 or 5, is regarded at this point as consent in law of your peers. And I think that you're getting power. You are getting the power of the consent of the peers out of it. But it's just that if there's only under 20 people, it's not going to be a really severe violation of public peace or threat. But you're getting the consent of people, and it's legitimately getting acknowledged as a official matter, right? Now, if you want more people, which is going to be more compelling evidence of more public concern, if you want like 100 or 300 or whatever people, right, in order to get them to consent officially, this is like official consent, legally acknowledged consent. If you want the legally acknowledged consent of more than 20 peers, which I think would be the lawful judgment of the peers in Magna Carta, if you want more than 20 lawful peers, then you've got to have it. You've got to go through an assessment, and it's the assessment, like I said, has got to be at the hundreds courts, the assizes, and by the if it's in London, it can be the mayor, an alderman, like in this Sean Penn and William Penn and William Mead case. It is with 3 aldermen and the mayor. Now, if Penn and Mead had been in London, because this was it was very near London Bridge. It's one of the London Bridge when you go up and it sort of branches to the right. That's where the street was that they were, not far from the London Bridge. One of the roads going straight up and then forking right from one of the London Bridge. So it apparently, if Penn and Mead had been doing a disorderly soliciting, petitioning, complaint, remonstrance, or whatever of this, 300 people, but if they'd have first gone to a court and got consent, then they would have been all right, right? If the consent is under 20, then you supposedly you have got if you really are officially doing this, you actually are doing it with the consent of the peers, right? And you are meant to have special rights and so forth, but not if it's over a certain amount of people and you don't get this special consent. So the special proceedings that you're meant to go through is for assent and consent and assessment, really, to do it on a larger scale with more people. Now, this is what I think is absolutely fascinating, and what this is the casework that we need to be reading. Where are these proceedings and cases? I would like to see them. Well, they're petitions, aren't they? And the thing is that the records of them are going to be you're going to find them in the hundreds courts records. I think you are going to find them in the hundreds courts records because that's the division of the county, and you're going to find them in the assizes and the quarter sessions, right? Now, I don't know what's going on when they changed the quarter sessions to courts in the amendments in 1967. There's something strange going on there. It doesn't seem correct. It seems odd. I don't know if they were trying to cover up the tracks, or if people are trying to find out and investigate this. So this Dr. Brodie Waddle has translated a lot of the petitions, so hopefully we can start reading some of them. But I'm interested in it's not just petitions. A lot of these proceedings, if they're in the assizes, they get like a recorder. So it will be recorded like this Penn and Mead case. But this Penn and Mead case is not the consent or the assessment stroke consent proceedings. What the Penn and Mead case is what happens if you don't get consent and you don't get an assessment, if you get this over 20 people without it, right? And then you get charged, right? You get prosecuted. And that's what's going on here. So they were accused of doing basically tumultuous petitioning without consent and approval of the court or even the mayor. So that was why the mayor might have been annoyed because, they've been accused effectively of getting large numbers of people in a political matter without getting the consent of the mayor or the alderman, because they're in London. So that's why the mayor would have been pissed off about it, right? If they had broken the law or not. So knowing that, so now I'm going to come to this manuscript that I've got. I don't know if it's an original. It looks like it might just be fancy, old-fashioned looking paper they've printed it on. It doesn't look like it's ever been bound. It's not been pulled out of a book. I don't know whether it's a copy of an original print, but it looks very, very genuine. So I guess I'm going to read this to you now. Let me see what you think to it, because that when people mention this and say, "Oh, there's a plaque in the Old Bailey," and say that juries have a right to make their verdict on their conscience, that plaque commemorates this case, but it's all about the jurors' rights. They've got a right to do it. Well, they knew that anyway. They knew they've got a right to do it because Mead and Penn are openly claiming Magna Carta in there, that the jury have got the right to do it all through this report, as you'll see. And they already know that the jury have got special protections. And they know that. One ironic thing in this is that the court recorder, and this is the thing, they didn't have what we've got now as a legal advisor who's meant to, well, some legal advisors are very, very good, and some legal advisors are terrible. But they had the recorder, but what you'll know is the recorder kind of is acting or behaving like what we'd regard as a legal advisor. But they're meant to be. I don't know how they can. I don't know how they can record every single thing that's said so quickly. While they're also engaging in the proceedings, as if they're sort of like a legal advisor. But that's how they did it anyway. It's a miracle that they got all the wording. I think this account is meant to be written by Penn and Mead themselves, possibly using the. I think they obtained the court records, and then this was compiled from that, but you can decide that yourself. So we've got, I'll read out who the jury are, although that's unlikely, it tells you like later on, but so they've got the jury set out as Thomas Vere, Charles Milson, Henry Mitchell, John Brightman, James Damask, William Plampfield, is it? William Lever, John Bailey, Gregory Wallace, Henry Henley, John Hammond, Edward Burble or Brycel. So that's who the jury were. And what's amazing about this is it's the actual mayor who is the judge or the chair, and then they've got three aldermen. One, two, three. I think there's 5 aldermen. So they've got Theo Howell is the recorder, Sam Starling is the mayor, Theo Bloodsworth is an alderman, William Peake is an alderman. John Robbins an alderman. Richard Ford an alderman. And Joseph Sheldon an alderman. And then there's two sheriffs. There's John Smith and James Edwards. I don't know if they're using those as two credible witnesses, but I don't know if you need two credible witnesses for this offence. It says for the second offence of having more than 10 people presenting a petition. Does it say that... I don't know if you need... I'm just checking now. Complainant shall... Filtration matters established law. Simple about personal shall from and after the when Liverpool procure getting of hands or consent persons above the number of 20 or more to petition. Petition complaint from time. Tended by any person no person. Right, I just noticed something. I'm just going back to the Tumultuous Act now. It said, provided always that this Act, nor anything hereby contained, shall be construed to extend or debar or hinder any persons or person not exceeding the number 20 to present any public or private grievance or complaint to any member or members of Parliament after his election and during the continuance of the Parliament or to the King's Majesty for any remedy to be thereupon had, nor extended on any address whatsoever to His Majesty. I think part of that last bit there, which I forgot to mention, if you've been elected to Parliament and you were all in Parliament, it would be a bit funny if, like, you know, there's a full Parliament assembled and they're presenting petitions. You have an assembly of people, so I think that could be like saying that, you know, what happens, you know, how do you operate in Parliament? You know, what if they present petitions to the King if you're a member of Parliament or a member of the House of Lords or whatever? I think it's got something to do with that. But why would you be wanting to present petitions to Parliament if there wasn't a Parliament? 3, provided always that this Act, nor anything therein contained, shall not be construed to extend, to debar, or hinder any person or persons not exceeding the number of 20 aforesaid. To present any public or private grievance or complaint to any member or members of Parliament after his election. So I think you can. I think that means that if you're in, if you don't need to have that first proceeding, that check-in and approval proceeding, you've got 20 people, I think you can give it to your member of Parliament, your MP, if they've been elected, or to the King. So I don't know what that, don't really know. Bit stumped with that one. It's looking like if it just says a private grievance or complaint. It looks like you're allowed to speak, or if there's under 20 people, you're actually allowed to talk to MPs or members of Parliament or the King about a complaint. But that's not a petition for one. It's got to be under 10. And maybe that's when there is no when there isn't a Parliament being held. But there's something in this to do with the fact that there's going to always be a lot of people around if you are an MP, and they've got to be able to do their work and job and so forth, and talk about issues and matters, which would be extremely difficult to do, wouldn't it? If no one can present any talk about any complaints with MPs in groups, then how can you in an assembly? I mean, then you would be getting into this ridiculous kind of issue with. What happens if an MP has to speak to the public about a grievance, and then all the crowd say, "Oh no, we don't agree with that"? Then would they immediately be arrested? If an MP, did turned up with a town crier to say something, and there were like 100 people around, and they said, "Oh, we don't agree with that. No, we all object." Then you could immediately arrest them all for objecting, right? That would be ridiculous, wouldn't it? So you can see some situations where you would, maybe you're not allowed. If there's over 20 people assembled, I guess you're not allowed to. If an MP makes a statement, then you couldn't. Would it be illegal to all say, right, we want to oppose this, and all officially agree? Unless you went to a court first and get approval. That means the crowd couldn't disagree with an MP officially as a group. Only 20 of them could, unless they go to a court. That means it could be illegal. That means like the MP would be like, whoa, what's going on here? We're getting a bit scared. I've just suggested some new legislation to the village. That's I never thought of that. That's quite interesting. Although also it mentions if he's been elected or not as well. Anyway, so I'm going to read this. I've been wanting to do this. This is a bit that I've been wanting to read. Well, I've just got today, and it's actually really enlightening. Really like it. This. Whoa. So. They got this crier. So they've got like a crier caught, and he shouts out, "Oh yes. Oh yes." Thomas Fear, Bribel, John Hammond, Charles Milford, Gregory Wallace, Walcott, John Brightman, William Femstead, Henry Hensley, Thomas Damask, Henry Mitchell, William Lever, John Bailey. I've got to go steady with this because they've got like some of the letters are like an F is an S, and I've got there's some like odd letters in there. I've got to kind of like, sometimes you've got to just like pause a second to get the words right when they changed the way they write it out. So it opens with the oath. The opening part of this document actually starts with the oath. So they're swearing in the jury. The start of this, the form of the oath. So it's the crier, oh yes, reads out the name of the jury, 12 of them. The form of the oath. So what form is the oath in? So I think that is a good hint. I think they're highlighting the fact that they're getting their peers. That they're forming they're putting their hand to it, because in this account later on, in this, when the jury writes their verdict, they actually write it down. They put their hands to it. So it is really almost like a petition to the court. It's almost like the form of the verdict is by petition to the court, but of 12 jurors. They do like read it out as well, but they have to put it in writing. So it's almost like this, it's kind of in a way almost like the petition is almost like an official document, a writ, an oath, a statement, a legal document of the peers, And I think that is the theme that runs through a lot of it. So, you shall well and truly try and true deliverance make bewitched our sovereign lord the king and the prisoners at the bar according to your evidence. So help you God. Wow. So we actually get to see the actual oath that the jurors take in 1670. So the crier shouts it out. He shouts, he reads their names out, and he said, you shall well and truly try and true deliverance make betwixt our sovereign lord the king and the prisoners at the bar, according to your evidence. So help you God. Now do you know what is interesting about that? It says according to your evidence. So you've got they've got 12 jurors there in a court, with everyone else present, and they are forming their oath of the jury of these 12 people. It's to form an oath that they will well and truly try the true deliverance betwixt our sovereign Lord and the prisoners at the bar, but according to your evidence. Well, the thing is that when you write up a petition, you're writing evidence, aren't you? If you are doing, I know that this is a trial, right? This is a prosecution, but what is interesting to reflect on is that when you draft up a petition, it's like, an affidavit or a civil case, your evidence. So it's framing what this actually does. It's a very good example of framing the jury in a court when they're under oath, right, and making a decision according to evidence. It's a good way of framing it to compare as a comparison to when you do a petition, and if you get 20 people to sign it, that this is your evidence, the evidence of the 20 people signing the petition to the king, because they are petitioning the king, aren't they? Because they're petitioning the king, right? That this is our evidence. It's almost like, really, when you have a legal state, when you bring a case, a civil case or a criminal case, you're meant to put statement of truth on there anyway, and it's through the king's courts by a lawful due process. So it's all meant to be, that's the point, a lawful due process of law. So, I mean, it according to the evidence, so it's just ringing a bell. It's ringing bells that, oh, well, that's what you do when you write a petition up. You're putting evidence, and then also evidence of the public concern, that the peers who sign it, and that really is their consent to you bringing the case and what you're doing in order to obtain and bring the evidence. So really, in my opinion, that is the Magna Carta, the judgment of the peers, but for the the witnesses, for the evidence of the case that has been brought and their consent to bring it, which is what assisting offenders is based on. The whole assisting offenders from the Criminal Law Act 1967, the pursuit of crime, the pursuit of evidence as well, pursuing criminals is what the CPS have adopted when they take on witnesses to assist them according to the evidence that they will collect is how they get under assisting offenders. So, and later on in this, I haven't even got there yet, the jury they've got a protection of jury. So, and I'm quite this is before the 1688 Bill of Rights, that it's the right of the subjects to petition the king and all prosecutions and commitments for doing so are illegal. We'll get to that in a minute, because this is what this old Bailey case is all about, the right of the jurors to make a decision by their own conscience. But they knew that, and we'll approach that. But I just wanted to, when it opens, and I think that the opening part of this is significant. That it opens with the oath, and that it is a number of persons who are going to be signing and writing a verdict down, and according to evidence under oath, which is what you do on a petition. You're subscribing through a lawful due process, setting out evidence and getting peers to subscribe to it. So you're definitely not committing a crime or the things that you're doing in order to pursue that, because they are supporting it. And that is the gotten power. I think that is the gotten power of the ability to do that, of which the king wasn't that impressed with, because people were abusing that power and getting, causing violations of public peace with large numbers of people. But I think they acknowledges there is a power that you use when you're doing it, just through the legal process. And this is before 1688, before the Bill of Rights. I think it's based on Magna Carta, the judgment of the peers, because I think that when you set out a grievance and many people agree with it and sign it, and I think that is the judgment of the peers, well, they're definitely judging whatever you're doing is reasonable action in pursuit of to bring the evidence and in pursuit of the matter. I think that's meant to be what the basis is for it, as far as I can gather. So you shall so help you God, right? You try the prisoners at the bar. The indictment sets forth that William Penn, Gent, and William Mead, late of London, linen draper. So there's a linen draper with diverse other persons to the jurors unknown. So they're claiming that they don't know who they are, right? To the number of 300, right? Now, the problem with the Tumultuous Petitioning Act, and remember that this is a trial of a tumultuous assembly, which would be disorderly soliciting in public, right? So I think that all 300, if they could get all 300 of them in, I think they probably would prosecute all of them. Definitely, if they were all presenting it to the king. But you need 2 or more witnesses, and So I don't know about the other witnesses, because you've got this. This is mainly about the jury, but you've got these sheriffs who are here, John Smith and James Edwards. But then you've got this other guy here, but it's not got anything next to his name. I don't know if I don't actually know whether he's a witness or not. He doesn't say. Mayor, recorder, 3 aldermen, or 5 aldermen, 2 sheriffs. But then you've got this crier and the clerk as well. But the clerk's not named. They just referred to him as clerk. So I don't know whether John Smith and James Edwards, the 2 sheriffs, why they're both appearing, if they were called out to this tumultuous assembly or not, or if they were reported to it. But no, there's only Penn and Mead are facing charges. So, but they're claiming there was 300 people involved in this disorderly soliciting in the streets or whatever, right? But they're saying unknown, other persons unknown. So potentially there could be 300 offences there if it's all one group of people, which I find interesting. The 14th day of August in the 22nd year of the king, about 11 of the clock in the forenoon, the same day, with force and arms, in the parish of St. Bennet, Grace Church in Bridgeward, London, in the street called Grace Church Street. Well, I looked on the map and it's where London Bridge is, or one of the London bridges. It's straight up from there, and then the road forks, and you go to the right. It's actually, I think it's called the A10 now, a section of the A10 in the middle of London. So, unlawfully and tumultuously did assemble and congregate themselves together to the disturbance of the peace. So that is, they're accusing them of violations of the public peace, right? Under a disorderly solicitations under the Tumultuous Petitioning Act, right? So this is one of the I didn't know that. I mean, are you supposed to know that? The Old Bailey case, I know there was some incident, but everyone just talks about, you know, the inside the courtroom events and the jurors' rights and so forth. But I think if more people would say, oh yeah, it's, you know, one of the prosecutions under the Tumultuous Petitioning Act, then it would kind of like make more relevance to people rather than just generally, you know, rights of jurors. No, this is a case under the Tumultuous Petitioning Act. Because there were large numbers of people. To the disturbance of the peace of the said Lord King and the aforesaid William Penn and William Mead, together with other persons, to the jurors aforesaid unknown, then and there, so assembled and congregated together, the aforesaid William Penn, by agreement between him and William Mead, before made, and by abetment of the aforesaid William Mead, and then and there in the open street did take upon himself to preach and speak. And then and there did preach and speak unto the aforesaid William Mead and other persons there in the street aforesaid, being assembled and congregated together, by reason whereof a great concourse and tumult of people in the street aforesaid, then and there, a long time did remain and continue in contempt of the said Lord King and of his law, to the great disturbance of his peace, to the great terror and disturbance of many of his liege. Well, we've got that word liege there. That's like allegiance, just people who, like, you know, obey the... That's an important word, actually, allegiance of his liege, people and subjects, to the ill example of all others in the like case offenders, and against the peace of the said Lord the King, his crown and dignity. So it doesn't actually tell us what they were talking about at this point. It doesn't say what they were preaching about, what the subject matter was at all. It just accuses them of getting, 300 people attention in the street. What say you? William Penn and William Mead, are you guilty as you stand indicted in manner and form as aforesaid, or not guilty? Right. So here now speaks Penn, right? William Penn. He says, it is impossible that we should be able to remember the indictment. It says the word, what's that, verbatim? And therefore we desire a copy of it, as it is customary in the like occasions. So that they're saying they don't want a plea until they have seen a copy of the indictment. Okay, so the recorder says to them, he says, you must first plead to the indictment before you can have a copy of it. Well, at this point, I want to intervene and note that they must have at some point got a copy of the recorder's record of proceedings from him, being able to write all this, because it's kind of a bit of a combination of the recorder's material and commentary in between. So it looks like I think that they ended up getting. Can you imagine, like in that, in the can you imagine in 1670 getting a copy of your court proceedings? There's hardly any documents surviving from there anyway. So he's not going to enter a plea until they give him a copy of it. You must first plead to the indictment before you have a copy of it. Penn, I am unacquainted with the formality of the law, and therefore, before I shall answer directly, I require two things from the court. First, that no advantage may be taken against me, nor I deprived of any benefit which I might otherwise have received. Secondly, that you will prove promise. Firstly, you will promise me a fair hearing and liberty of making my defence. Court. I don't know who's speaking on behalf of the court. I'm guessing it's like the alderman. I'm not sure. No advantage shall be taken against you. You shall have liberty. You shall be heard. Penn. Then I plead not guilty in manner and form. So the clerk says, what sayest thou, William Mead? Art thou guilty in manner and form, as thou standeth indicted, or not guilty? Mead, I shall desire the same liberty as is promised. William Penn. Court, you shall have it. Mead, then I plead not guilty in manner and form. So he says that he shall desire the liberty. I wonder if that they're doing, if they've got political matters and political issues, that if they were pursuing a political matter in the street, maybe they should have had the right of the petition, protection of, the consent of the people or whatever, or the matter. But I think the thing with this case is that I just want to note here, what happens is the jury, we'll get to it in a minute, but the jury effectively said that they're guilty of just talking in the street, that it's just talking, it's not actually soliciting, petitioning, procuring, or anything for a political matter. The jury just say, they're just talking in the street, and then later on they say not guilty. So the jury are claiming that they weren't doing a petition, right? The jury are claiming that they weren't doing a petition, therefore they haven't broke the law of the Tumultuous Petitioning Act, or they weren't soliciting all these people in a political cause, right? To get their consent to a political cause. I think the jury say they weren't, right? So therefore they're not guilty of the offence. But if they're not guilty of the offence, if they weren't soliciting and petitioning people to consent to a political cause, right, for, Parliament, etc., then if you're not doing that, you're not using the right to petition, and you ain't got the right to petition protection, because if you haven't, but you were breaking the law though. So I need to point that out. There's a very, very interesting and kind of intellectual, ingenious thing going on there, because if they've got 300 people there and they're petitioning, right, or getting people to consent to their political cause, it's over 300 without prior approval, and then they're committing an offence, right? But if it's under 20 people, then they can do it, and they've got a liberty and privilege through law if they were doing a petition or political action without the 1688 Bill of Rights anyway. But if they go over this 20 people without consent or permission from a court, then it's an actual proper offence to do that, right? Now, the ironic thing about this whole story, which is not really even entertained in that plaque on the wall, is all completely separate from the right of the jury and, to make their conscience. This case is so amazingly interesting and so much more diverse and rich in irony and contradiction. It's like the case study itself is an exceptional case study on all levels, and I think this plaque on the Old Bailey is diluting it down to this right of jurors to make a decision based on their conscience, which that is not even the half of this case. It's not even the half of this case. It's full of other legal quirks around the Tumultuous Petitioning Act, situational quirks. Right, so we've got to this. They've both entered their pleas not guilty, but they want to have their liberties, right? So so I don't know whether they're claiming that. So if they're not guilty, are they claiming that they weren't doing a petition, or are they claiming that they didn't solicitate over 20 people? I'm not quite sure. You see, this is the thing with Extinction Rebellion. Are they petitioning or not? Well, according to the Tumultuous Act, it includes soliciting people, procuring of the hands to signatures, complaints generally, remonstrances, which is kind of really, I think remonstrance is the area of which Just Stop Oil and Extinction Rebellion probably fall within remonstrances, declarations, other addresses to the King or both or either Houses of Parliament, and violations of public peace is what is the result of. So I'm a little bit confused as to if they're pleading not guilty. Are they claiming that they didn't? This is the interesting mystery with this is, by both pleading not guilty but wanting their liberties in place, are they saying that we've got protection and immunity, and we weren't soliciting over 20 people, or are they saying that we weren't even we're not engaging in affairs of state, religion, or law in the streets, where we're just talking to people, I'm not allowed to talk to 300 people in the streets about, something or nothing. I don't think that it tells you in this. It doesn't tell you what they're talking about. That's interesting because Extinction Rebellion are all about why they want everyone to know about what it's about. Oh, we're saving the environment, or it's global genocide, or whatever it is. That's what they wanted to talk about, and the courts have said they're not allowed to mention it anymore. Well, they don't seem to mention it in this, and I don't think if you got prosecuted with the other offence, then that's just for presenting it with large numbers of people. They don't really care. They're not interested in what it's about in the slightest. Just that there was a large number of people there. With this offence, it doesn't matter. It's all about number of people. But in this, they're wanting to know. It matters in this if you are engaged in political matters or not, because that's kind of what makes the offence. But if they would have had this other legal action in the first place, they would have got this assessment, consent and permission, and then they could go ahead and do what the hell they wanted, which is ironic, really, now that this Tumultuous Act has been repealed around the time the CPS was formed, because really, you kind of want this because it gives you an opportunity to officially get recognised and set out your terms, although you didn't need to if it was under 20 people. Like, I've got my petition registered with Parliament. I'm guessing that really now, what's actually, I think what this does is, if you go on the Parliament website now and you get listed and recorded and published, and you've got the signatures on and they're all recorded by postcode, I'm pretty sure that's your consent. I think you've got your consent. But only up to that number of people. So unless Parliament, the thing is, if Parliament, if you don't get under 20 signatures, it doesn't get actually put on the main website, but you've still registered it. And you can actually get consent with it and get it published, like I actually ended up doing. Mine did actually get published, but I didn't end up collecting any more signatures than that. So, but it's definitely been given consent past this stage that they had in the Tumultuous of proceeding. So, really, you've been given the go-ahead with your case and consent to the matter. So, that's what I'm thinking at the moment with the petitions that are listed on the website, which you would have thought that applies for Dave Fowler as well with Stop ULEZ, because that's officially on there. Although they've got signatures on change.org as well, over 400,000, I think. Anyway, so let's get back to this now. So they've entered the pleas, right? So the court speaking now. No advantage shall be taken against you. Then plead not guilty, and I want my liberties. You shall have it. Mead, and plead not guilty. And all right. So now what happens is the court adjourned until the afternoon, right? So the court adjourned, and then we come back in with a crier, because this. Oh yes, I don't know how they used to say that, but it would have been interesting to hear how they used to do it. Almost like a town crier, hear ye, ain't it? But they used to say, oh yes, apparently. Clark, bring William Penn and William Mead to the bar. Obser. I don't know what that OBF, this got one of those weird letters. Obser. The said prisoners were brought. I think it might mean something like an orator, because this part is kind of like the narration part about it, which gives a narration. It's not the recorder speaking, but it's kind of like narration. Or I think this is kind of meant to be like like an orator or whatever, but it's like it says OBFER, but I think that F is an S. So I'm gonna regard it as like an orator or something. So the said prisoners were brought, but were set aside, and other and Other other criminals prosecuted. Other. So, like, basically, it's saying that I can't read that word. Buffenal. So it says other people were prosecuted, right? So they put Mead and Penn to the side in the court and ended up going through with some other prosecutions, where we cannot choose to observe that it was the constant and unkind practices of the court to the prisoners to make them wait upon the trials and felons and murderers, thereby designing in all probability both affront and tire them. Designing probability to affront. So after 5 hours attendance, the court broke up and adjourned to the third instant. So they basically adjourned it, and they got them back in, and they put them to the side, and they prosecuted loads more criminals. Right? Right, so I don't know why they did that. So they're saying that they just made them wait, and they made them wait while they were prosecuting loads of other cases, right? Felons and criminals, whether it's to break their spirits or wear them down or tire them out. Now, if Penn and Mead were confident that they've got some sort of petitioning right, privilege or protection over political matters, right? They might have been confident, but then if they see all these people getting prosecuted, then it probably would make them feel less confident, right? Because remember, even though this is before 1688, I think all these privileges are actually already in use and known of and acknowledged. That's the thing, right? So, after 5 hours attendance, the court broke up and adjourned into the third instant. Right, the 3rd of September, 1670, the court sat. So they didn't even actually hear their case there and then. They just got them to enter a pleas, and then they kind of like made them wait there, and then they broke up. Crier. So this is on the 3rd of September. Oh yes. Clerk. Bring William Penn and William Mead to the bar. Mayor. Right? So now we've got the mayor. Sarah, who bid you put off their hats? Put on their hats again. Orator, whereupon the officers putting the prisoners' hats upon their heads, pursuant of the order of the court, brought them to the bar. So they didn't have their hats on, and the mayor told the security guards to put their hats on their heads. Right? Recorder, do you know where you are? Penn, yes. Recorder, do not you know it is the King's Court? So that's like trying to make out that, you know, all courts are the King's Court, like whether it's a hundreds court, assizes, a mayor. I think it's trying to like make out that, you know, all courts are the King's Court. Do you not know it is the King's Court? Interesting, because it's not actually the King's Bench. They've got the King's Bench as a special court, but they're still saying it's the King's Court, right? I think this dialogue is important at a later stage if this case is well known and well recorded in detail. When they make the 1688 Bill of Rights, illegal prosecutions by the King's Bench. If Penn and Mead's records of proceedings are anything to go by, given that this is like 9 years after this Tumultuous Act, and it's only another 18 years after this. So I know it's a long time, 18 years, but if it is a landmark case that got a plaque on the wall, maybe it had some bearing on the people who ended up making the Bill of Rights. And I'll say something about that in a minute, actually, when we get to the end of one of these pages. But anyway, so he's like, the recorder's like, do you not know it is the King's Court? I know it to be a court, Penn, and I suppose it to be the King's Court. Recorder, do you not know there is a respect due to the court? Recorder, so he's asked him if there's some sort of respect due. Penn says yes. Recorder, why do you not pay it then? Penn, I do, sir. Recorder, why do you not pull off your hat then? Penn, because I do not believe it to be any respect. So they had their hats off when they came in, and then they got the mayor, who was judge, got the security guards to put the hat back on their heads. But then they're being accused of not taking their hats off, right? And then Penn's going, well, I don't believe it to be any respect. Recorder, well, the court sets forth marks apiece upon your heads. 40 marks apiece on your heads as a fine for your contempt of court. Can you believe that? So the mayor, who is judge, they come into the court without their hats on, and he tells the security guards to put their hats on their heads. Then he accuses them of being in contempt of court for not taking their hats off. Can you believe this guy? He playing games with them. And he's going to fine them 40 marks apiece for being in contempt of court. Penn, I desire it might be observed that we came into the court with our hats off, that is, taken off, or he took them off. And if they have been put on since, it was by order of the bench, and therefore not we, but the bench should be fined. So Penn is saying that because the mayor told the security guard to put the hats on, that the mayor's in contempt of court himself, not them, which is quite hilarious. This is actually amazing, astounding proceedings. Although I suppose that some of the proceedings of Extinction Rebellion, when they're climbing on the tables and all kinds of antics, probably match some of these, particularly that Rob the Ratcatcher guy who was attempting to arrest the judges. That's got to be a classic. But this is quite funny. So it's not we that should be fined, but the bench that should be fined. Mead, I have a question to ask the recorder. Am I fined also? Recorder, yes. So because he put hats on both of them, so he's asking if he's got fined as well. Mead, I desire the jury and all people to take notice of this injustice of the recorder who spoke to me to pull off my hat, and yet hath he put a fine upon my head. O fear the Lord, and dread his power, and yield to the guidance of his Holy Spirit, for he is not far from every one of you. Wow. The jury sworn again. Orator. J. Robinson, Lieutenant of the Tower, discommonly objected against Bushell, as if he had not kissed the book, and therefore would have him sworn again. Though indeed it was on purpose to have made use of his tenderness of conscience in avoiding reiterated oaths, to have put him by his being a ferryman, apprehending him to be a person not fit to answer their arbitrary ends. The clerk read the indictment as aforesaid. Clerk, crier, call James Cook to the court, give him his oath. Clerk, James Cook, lay your hands upon the book. The evidence you shall give to the court, herewith our sovereign the king, and prisoners at the bar, shall be the truth, and the whole truth, and nothing but the truth, so help you God. Cook, I was sent for from the exchange to go and disperse a meeting. All right, so they're giving evidence now. So Cook's giving evidence. James Cook. I don't know if is Cook listed on here, and I don't think Cook's not listed on there. So Cook's one of the witnesses, but he's not listed for some strange reason. So this is the first. I think this is the first witness then. I was sent for from the exchange to go and disperse a meeting in Grace Church Street, where I saw Mr. Penn speaking to the people, but I could not hear what he said because of the noise. I endeavoured to make my way to him, but I could not get to him because of a crowd of people, upon which Captain Mead came to me about the kennel of the street and desired me to let him go on, for when he had done, he would bring Mr. Penn to me. Court, what number do you think there might be? Cook, about 300 or 400 people. Court, call Richard Reed, give him his oath. Reed being sworn was affected. What do you know concerning the prisoners at the bar? Reed, my lord, I went to Grace Church Street, where I found a great crowd of people. I heard Mr. Penn preaching to them, and I saw Captain Mead speaking to Lieutenant Cook, but what he said I could not tell. Mead, what did William Penn say? Read, there was such a great noise I could not tell what he said. Mead, jury, observe this evidence. He saith he heard him preach, and yet saith he doth not know what he said. Jury, take notice, He swears now a clean contrary thing to what he swore before. Mayor, when we were committed, from now he swears that he saw me in Grace Church Suite, and yet he swore before the mayor when I was committed that he said he did not see me. I appealed to the mayor himself, if this not be true, but no answer was given. Court, what number do you think might be there? Read, about 400 or 500. Penn, I desire to know of him what day it was. Read, the 4th day of August. Penn, did he speak to me or let me know he was there, for I am very sure I never saw him. Clerk, crier, call. There's a line there, I don't know why, into the court. Court, give him his oath. There's a line. So someone's name has been left out. My lord, I saw a great number of people, and Mr. Penn, I suppose, was speaking. I saw him make a motion with his hands and heard some noise, but could not understand what he said. But for Captain Mead, I did not see him there. Recorder, what say you, Mr. Mead? Were you there? Mead, it is a maxim in your own law, Nemo tenure accufer fenium, which, if it not true Latin, I am sure it is true English, that the man is bound to accuse himself. And why dost thou offer to ensnare me with such a question? Doth it not show thy malice? Is it like unto a judges that they ought to be counsel for the prisoner at the bar? Recorder, sir, hold your tongue. I did not go about to ensnare you. Penn, I desire we may come more close to the point, and that silence be commanded in the court. Crier, oh yes, all manner of persons keep silence upon plain of imprisonment, silence in the court. Penn, we confess ourselves to be so far from recanting or declining to vindicate the assembling of ourselves to preach, pray, or worship the eternal, holy, just God. That we declare to all the world that we do believe it to be our independable duty, or indefinable duty, indispensable duty to meet incessantly upon so good an account, nor shall all the powers upon earth be able to divert us from receiving and adoring our God who made us. So it looks like it looks like it might have been some kind of religious endeavour, this 300 people in the streets shenanigans. Brown, you are not here for worshipping God, but for breaking the law. You do yourselves a great deal of wrong in going on in that discourse. Penn, I affirm I have broken no law, nor am I guilty of the indictment that is laid to my charge. And to the end the bench, the jury, and myself with these that hearers may have a more direct understanding of this procedure, I desire you would let me know by what law it is you prosecute me, and upon what law you ground my indictment. Recorder, upon the common law. Penn, where is that common law? Recorder, you must not think that I am able to run up so many years and over so many adjudged cases that we call common law to answer your curiosity. Penn, this answer, I am sure, is very short to my question, for it be common. It should not be so hard to produce. All right, he actually wants to know which actual clause or law that he's broken, but he's not telling him specifically. It should not be so hard to produce. Sir, will you plead to your indictment? Penn, shall I plead to an indictment that have no foundation in law? If it contained that law you say I have broken, why should you decline to produce that law? Since it will be impossible for the jury to determine or agree to bring their verdict who have not the law produced, by which they should measure the truth of this indictment and the guilt or contrary of my fact. Recorder, you are a saucy fellow. Speak to the indictment. Penn, I say this is my place to speak to matter of law. I am arraigned a prisoner. Arraigned. He's using that word arraigned like they do with Trump. I am arraigned a prisoner. My liberty, to which is next to life itself, is now concerned. You are many mouths and ears against me, and if I must not be allowed to make the best of my case, it is hard. I say again, unless you show me and the people the law you ground your indictment upon, I shall take it for granted that your proceedings are merely arbitrary. It's a nice word, arbitrary, because we've got diverse and arbitrary courses. They use that in the 1688 Bill of Rights. Others at this time, several upon the bench, urged hard upon the prisoner to bear him down. At this time, several upon the bench. So they tell him to bet you. I think they're giving him a bit of punishment. I think that they were saying this to that Rob the Ratcatcher guy when he was in court. Getting him, roughing him up a bit, effectively. Recorder. The question is whether you are guilty of this indictment. Penn, the question is not whether I am guilty of this indictment, but whether this indictment be legal. It is too general and imperfect an answer to say it is the common law, unless we knew both where and what it is. For when there is no law, there is no transgression, and that law which is not in being is so far from being common that it is no law at all. Recorder, you are an impertinent fellow. Will you teach the court what law is? It's lex non for scripted. That which many have studied 30 or 40 years to know, and would you have me to tell you in a moment? That's the recorder speaking. This is 8 years after the Tumultuous. Penn, certainly, if the common law is to be understood, it's far from being very common. But if the Lord Coke in his institutes be of any consideration, he tells us that common law is common right, and that common right is the great charter privileges confirmed. 9 and 3, 29, 25, 1, 2, ed 3, 8. Recorder, sir, you are a troublesome fellow, and it is not the honour of the court to suffer you to go on. Penn, I have asked but one question, and you have not answered me. Though the rights and privileges of every Englishman be concerned in it. So he's talking about privileges and rights of every Englishman now, and the recorder's not telling him what offence that he's been charged with. Recorder, if I should suffer you to ask questions till tomorrow morning, you would be never the wiser. Penn, that is according to the answers are. Recorder, sir, we must not stand to hear you talk all night. Penn, I design no affront to the court, but to be heard in my just plea, and I must plainly tell you that if you will deny me over of that law which you suggest I have broken, you do at once deny me an acknowledged right. You at once do deny me an acknowledged right, and evidence to the whole world your resolutions to sacrifice the privileges of Englishmen to your sinister and arbitrary designs. Recorder, take him away. My lord, if you take not some course with this pertinent fellow to stop his mouth, we shall not be able to do anything tonight. So, I'm wondering if Penn wants him to actually say, oh, if you're breaking the Tumultuous Petitioning Act, then maybe he's accusing him of doing some sort of political thing, petitioning, and therefore, if he wasn't doing it to over so many people, then he would have some sort of protection, as in privilege and rights that they're mentioning, but he's not saying that he's prosecuting him under the Tumultuous Petitioning Act, is he? He won't tell him. I think they mentioned disorderly soliciting, but he hasn't told him exactly what offence it is, and he's not getting out of him. So it's almost a little bit like Extinction Rebellion when they're in there, but they're not acknowledging that they're actually doing petitioning under any acts, you know. But even with Angela Ditchfield, you know, they didn't even acknowledge the Town and Country Planning Act. And this is now in modern law when it's very, very detailed and specific. They're just using, I beg your pardon, that Criminal Law Act. Diverse and so the mayor speaks now. Take him away. Turn him into the bail dock. Penn, these are but so many vain exclamations. It is justice, or is this justice or true judgment? Must I therefore be taken away because I plead for the fundamental laws of England? So he has referred to the Magna Carta, the Great Charter. However, this I leave upon your consciences, who are of the jury and my sole judges, that if these ancient fundamental laws, which relate to liberty and property, are not limited to particular persuasions in matters of religion, must not be indispensably maintained and observed. Who can say he have right to the coat upon his back? Certainly our liberties are openly to invaded. Our liberties are open to be invaded. I don't know if he's maybe it could be that if all those people in the street are consenting to him speaking to them, then he's like got the consent of them. But depending on if obviously if it's not over 20 or not, they're not calling him. All right, I think that they're going to mention it in a minute now. Actually, I've just seen down the page the word appear, so it's like halfway down this next page now. Our wives to be ravished, our children slaved, our families ruined, and our estates led away in triumph by every sturdy beggar and malicious informer as their trophies, but our pretended forfeits and conscience take. The Lord of heaven and earth will be judge between us in this matter. Recorder, be silent there. Penn, I am not to be silent in a case wherein I am so much concerned, and not only myself, but many 10,000 families besides. Orator, they, having rudely bailed him into the bail dock, William Mead, they left in court, who spoke as followeth. Mead, you men of the jury, here I do now stand to answer to an indictment against me, which is a bundle of stuff, full of lies, half-hoods, and herein I am accused, that I met V. Armis in this squad, Tumultuous, right, Viamis illicit and tumultuous, right? So I think that's I'm accused that vi and armis illicit and tumultuous. So he's saying that he's now. So William Mead is saying now to the jury, he's saying that he is accused of armi vi and v and armis illicit. This is in Latin, but it's vi and armis illicit and tumultuous. So it's in Latin, but he's saying that he's accused of illicit tumultuous illicit. So I'm guessing that is. I'm pretty certain that they're saying that it's from an unlawful tumultuation of some sort. Time was when I had freedom to use a carnal weapon, and then I thought I feared no man, but now I fear the living God, and dare not make use thereof, nor hurt any man. Nor do I know I demean myself as a tumultuous person. We're definitely under the Tumultuous Act here now. I think we've brought into acknowledgement of that act, although it's entitled Trial of William and Penn Bailey for a Tumultuous Assembly, but in the actual dialogue, they haven't actually mentioned it until now. They've only just brought up that in the dialogue. So, I say I am a peaceable man, therefore it is a very proper question that William Penn demanded in his case an order of the law on which our indictment is grounded. Recorder, I have made answer to that already. In this case, an order of law on which our indictment is grounded. So I think that they've acknowledged that it's some tumultuation, it's some tumultuous conduct, but I don't think that they've got the exact charge nailed down. Because, you'd need to be saying that this was, disorderly soliciting, or were they procuring the hands of the people unlawfully, or were they remonstrating or making a declaration? and I think that they're not actually. I don't think they're. I think they're wanting to. Effectively, I think what they're both saying is that, like, oh, you did this. You tried to get these 100 people to sign this, or you tried to get them to agree to that. That we should go make Parliament change the laws in this, or we should complain to the king about this or that. So I think that I think they're accusing. They're saying that they haven't specified the exact, under this act, exactly what it was that they did, which constitutes an offence, So the recorder, I have made answer to that already. Mead, turning his face to the jury, saith, you men of the jury, who are my judges, if the recorder will not tell you what makes a riot, all right, what makes a riot, a rout or unlawful assembly. Coke, he that once they called the Lord Coke, tells us what makes a riot, a rout, an unlawful assembly. A riot is when 3 or more are met together to beat a man, or to enter forcibly into another man's land, to cut down his grafts, his wood, or break down his pales. Orator, here the recorder interrupted him and said, I thank you, sir, that you will tell me what the law is, forcefully pulling off his hat. Mead, thou mayest put on thy hat and have never a fee for thee now. Brown, he talks at random, one while an independent, another while some other religion, and now a Quaker, and next a pulpit. Mead, terp eftamasicum, so that's in Latin. Mayor, you deserve to have your tongue cut out. This is quite a while after they used to cut people's ears off. That was the 1640s. Recorder, if you discourse on this matter, I shall take occasion against you. Mead, thou didn't promise me I should have fair liberty. Didn't thou promise me I should have had fair liberty to be heard? Why may I not have the privilege of an Englishman? I am an Englishman, and you might be ashamed of this dealing. Recorder, I look upon you to be an enemy of to the laws of England, which ought to be observed and kept. Nor are you worthy of such privileges as others have. Right, so we're really getting into this now. This is like, whoa. This is like, we're not even onto the jury and the plaque and the people make juries deciding on their conscience. Forget that. We've got like the recorder. He's saying that there are privileges and they do exist, but you don't deserve them. I look upon you to be an enemy. You're not about being innocent until being proved guilty. You're meant to be innocent until proved guilty. The recorder, who's effectively acting as a legal advisor as well, we didn't actually have a legal advisor then, and this is not the mayor. He's saying, I look upon you to be an enemy to the laws of England. Such ought to be observed and kept. Nor are you worthy of such privileges as others have. So he's saying that there are privileges and other people have them, but not him. He's saying that he doesn't have any privileges and that he's an enemy to the laws of England. He's not even been proved guilty yet. I was Keir Starmer say to that. In a courtroom, innocent until proved guilty. You probably get, if a judge said that now, he probably would get, you get to Judicial Conduct Investigation Office saying that now. I look upon you to be an enemy to the laws of England, which ought to be observed and kept. Nor are you worthy of such privileges as others are. So he's basically saying that people have got rights, but not you. You don't deserve to have any rights. So that definitely would get you in the Judicial Conduct Investigation Office for certain. Or not short of, well, nowadays, I don't think you could threaten to cut someone's tongue out. I think if a judge threatened to cut someone's tongue out now, that'd probably get him in the Judicial Conduct Investigation Office as well. And also, messing around with people, taking the hat off, telling the security guard to put someone's hat on, and then saying they're in contempt of court for putting their hat on. That would probably get them in the Judicial Conduct Investigation Office as well. I think they're just trying to get some respect from the court, but they're doing it a little bit more rough-handedly than they do nowadays. I think that it's this riot. It's looking like they're claiming that just because they were talking to 300 people that they'd started a riot, but then he's effectively saying, well, what is the definition of a riot? He's referring to Lord Coke, saying that a riot is when loads of things get broken and stuff like that. This is the problem with Extinction Rebellion at the moment, isn't it? They're trying to say what is rioting and not rioting, and what is just public breaking of the peace, or remonstrance. The thing with remonstrances is that it's making a point out of something, or making a political example, or now we've got an advertisement, making an advertisement to advertise a campaign, or doing making a model, an artwork, a model, or something which. And it raises up the 1688 Bill of Rights, an enactment that you can use for it specifically, and you've got deemed and expressed consents, but we're not too sure. Well, the juries have been finding them not guilty based on their own opinion, but then we've got some judges are saying that you can't have that or you can't do that, which is what's happening in some of these cases. But this is what this case is meant to prove about the jury. But he's saying that people do have rights and that they exist, but they just don't deserve them. And I think that's how the jury end up getting treated in this, because there's an acknowledgement of protection of the jury, but they start to say that they don't deserve the protection at some point. So Mead, the Lord is judge between me and thee in this matter. Orator, upon which they took him away into the bail dock, and the recorder proceeded to give the jury their charge as followeth. Recorder, you have heard what the indictment is. It is for preaching to the people. So now the recorder is saying that the indictment is for preaching to the people, not of a riot, and drawing a tumultuous company after them. So that's like a large number of people under the Tumultuous Act for sure, of 300 people, a tumultuous company after them. Claiming that because they're clearly considering it as over some kind of religion. Yeah, it can be over a matter of religion, can't it? A tumultuous gathering, trying to make out that they were trying to, but it would have to be addressed to either of Parliament or the King, though, and they would pursue getting something done about it, though. And Mr. Penn was speaking. If they should not be disturbed, you see they will go on their are 3 or 4 witnesses that have proved this, and he did preach there that Mr. Mead did allow it. After this you have heard by substantial witnesses what is said against them. Now we are upon the matter of fact, which you are to keep to and observe as what hath been fully sworn, at your peril. Orator, the prisoners were put out of the court into the bail dock, and the charge given to the jury in their absence, at which W.P., with a very raised voice, it being a considerable distance from the bench, spoke. William Penn. I appeal to the jury, who are my judges, and this great assembly, whether the proceedings of the court are not most arbitrary and void of all law, in offering to give the jury their charge in the absence of the prisoners, I say it is directly opposite to and destructive of the undoubted right of every English prisoner, as Coke in the second inflict of 29 on the chapter of Magna Carta speaks. So he's referring to, this Sir Coke, who must have given opinions on Magna Carta that he's probably heard or read. The recorder being thus unexpectedly left of his extrajudicial procedure, said with an enraged smile, Recorder, why ye are present, do you hear? Do you not? Penn. No thanks to the court that commanded me into this to the bail dock, and you of the jury take notice that I have not been heard. Neither can you legally depart the court before I have been fully heard, having at least 10 or 12 material points to offer in order to invalidate their indictment. Wow, so he's saying that lawfully he's got, he should have be able to make 10 or 12 proper legal points. He went on to that Magna Carta of Sir Coke, but the recorder started kind of evilly grinning at him and kind of shut him up now. Recorder, pull that fellow down. Pull him down. Why is it always like that? There's a lot of people now on Verbs' channel being going, I went to court, and there's like, take him down, take him down. They're gonna take him down. They still do that now. Pull him down. They're obsessed with it now. 2023 from 1670, and we've still got judges on take him down. So like metaphorically, isn't it? Pull his soul through the floor. Pull that fellow down. Pull him down. Mead. Are therefore, according to the rights and privileges of Englishmen, that we should not be heard but turned into the bail dock for making our defence, and the jury to have their charge given them in our absence, I say therefore are barbarous and unjust proceedings. Recorder, take them away into the hole. To hear them talk all night as they would, that I think doth not become the honour of the court, and I think you, i.e. the jury, yourselves should be tired out and not have patience to hear them. Orator, the jury were commanded up to agree upon their verdict. Wow. The prisoners remaining in the stinking hole. After an hour and a half's time, 8 came down, agreed, but 4 remained above. The court sent an officer for them, and they accordingly came down. The bench used many unworthy threats to the 4 that dissented, and the recorder, addressing himself to Bruthel, said, "Sir, you are the cause of this disturbance, and manifestly through yourself an abettor of the faction. I shall set a mark upon you, sir." J. Robinson, Mr. Bushell, I have shown you near this 14 years you have thrust yourself upon this jury because you think there is some service for you. I tell you, you deserve to be indicted more than any man that hath been brought to the bar this day. Bushell, no, sir, John. Or is that? There were 3. There were 3 court. 3 saw. There were 3 saw before me, and I would willingly have got off, but I could not. Bleed. Oh, that's blood. What do you call it? That's Bloodworth, I think. Bloodworth. I said when I saw Bloodworth's one of the aldermen. Bloodworth. I said when I saw Mr. Bushell, I said what I see is come to pass, for I knew he would never yield. Mr. We know what you are, Mayor. Sire, you are an impudent fellow. I will put a mark upon you. All these threats, violence. They used much menacing language and behaved themselves very imperviously to the jury, as persons not more void of justice than sober education. After this barbarous usage, they sent them to consider of bringing in their verdict, and after some considerable time they returned to the court. Silence was called for, and the jury called by their names. So it's not actually easy to read this because there's all like weird letters in. So I've got to kind of like I've got to make my mind up what the word is as I'm reading it, depending on what weird letters they've got in there. And some's like in italics. Clerk, are you agreed upon your verdict? Jury, yes. Clerk, who shall speak for you? Jury, our foreman. Clerk, look upon the prisoners at the bar. How say you? Is William Penn guilty of the matter whereof he stands indicted in manner and form, or not guilty? Foreman, guilty of speaking in Gracechurch Street. So this comment now, this is where we get into the plaque now. That plaque in the Old Bailey on the wall, and the jury have got the right to decide on their own conscience. Now we're getting into like what it says on that plaque, which is not the half of the story, really. So this is now when that comes into it. So the foreman of the jury, he says they're guilty, but of just speaking in Gracechurch Street. They're guilty of speaking in Gracechurch Street. Well, that's not an offence. Talking in the street is not a crime, not in any act of law. So they're kind of like, it's not the charge. They're like, it's like someone being on trial for punching someone in the face, and then saying, "Oh, I find them guilty of, crossing the road or something, or picking up a paperclip or something like that." So they're kind of being coy. Court, is that all? Foreman, that is all I have in commission. So they call it a commission. That is all I have in commission. Recorder, you had as good say nothing. Well, he's basically saying you might as well have said nothing. Mayor, was it not an unlawful assembly? Was it not an unlawful assembly? You mean he was speaking to a tumult of people there? Foreman, my lord, this is all I had in commission. Narrator, here some of the jury seemed to buckle to the questions of the court, upon which Bushell, Hammond, and some others afforded themselves, and said they allowed no such word as an unlawful assembly in their verdict, at which the recorder, Mayor, Robinson, and Bloodworth took great occasion to vilify them with most atrocious language. And this verdict not serving their turns, the recorder expressed himself thus. Recorder, the laws of England will not allow you to part till you have given your verdict. Jury, we have given our verdict, and we can give in no other. Recorder, gentlemen, you have not given your verdict, and you had a good say nothing. Therefore, go and consider it once more, and we may make an end of this troublesome business. Jury, we desire we may have pen, ink, and paper. Narrator, the court adjourned for half an hour, which being expired, the court returned, and the jury not long after. The prisoners were brought to the bar, and the jury's names called over. Clerk, are you agreed on your verdict? Jury, yes. Clerk, who shall speak for you? Jury, our foreman. Clerk, what say you? Look upon the prisoners. Is William Penn guilty in manner and form as he stands indicted, or not guilty? Foreman, here is our verdict. Holding forth a piece of paper to the clerk of the peace, which follows. So they asked for some pen and paper to write it down. Maybe they're hinting at, if you're doing a petition unlawfully, then, it would be written down on paper, and people would have signed it, put their hands to it, put their hands to a tumultuous petition, But there's only 12 of the jury, remember? The prisoners were brought... the court adjourned. All right, so the prisoners were brought to the bar, and the jury's names called over. Have you ever heard it? Yes. So you speak. Who shall speak? Our foreman. What say you? Look upon the prisoners. Is William Penn guilty in manner and form, as he stands indicted, or not guilty? Foreman. Here is our verdict. Holding forth a piece of paper to the clerk of the peace, which follows. Right? This is what he said on the paper. We, the jurors, hereafter named and find William Penn to be guilty of speaking or preaching to an assembly. We, the jurors hereafter named, do find William Penn to be guilty of speaking or preaching to an assembly met together in Gracechurch Street on the 14th of August 1670, and that William Mead is not guilty of the said indictments. And it's got all the names signed. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. All of the names. This both mayor and recorder resented at so high a rate that they exceeded the bounds of all reform and civility. So they've actually gone and got some paper, and it's almost like they've made a little petition, and they asked for some pen and paper. They got asked what the verdict was earlier on, just verbally, but then they got it rejected. So they've gone and asked for pen and paper, and they've written a little petition out with their names all on it. And they've said, we find him guilty of speaking and preaching to an assembly, but not guilty of the said indictments. So they've made of themselves a little petition and kind of winding up the judge. So this is like Ian Bray and Gregory Perrin's material, this. I think there should be a plaque on the wall with that Gregory Perrin's case for Ian Bray. Mayor, what will you be led by such a filthy fellow as Bushel, as impudent canting fellow? I warrant you, you shall come no more upon juries in haste. You are a foreman indeed. Addressing himself to the foreman, I thought you had understood your place better. I'm quite surprised why. I won't be surprised if the police have been culling many people from jury service by all their speeding fines among the nation. So they're like, trimming it down to, maybe culling the pool of jurors. I don't know. I've never had jury duty. I think they wrote a lot of people off early. Probably more people who are more lenient and kind as well, liberal people. And the thing with the jury is you're meant to be able to decide on your own opinion, on the opinion of the peers, not necessarily law, which is forgiveness. So if the police have been doing some kind of like undercover jury culling, I won't be, there's no forgiveness in that, is there? It won't surprise me. because I pretty much got that traffic light fine through not long after I actually ended up learning to drive on bottom of the moor, top of the in Oldham, bottom of the moor, top of the moor in Oldham. I've never been on jury duty. I think there's a little trick to try and strike people off the list secretly. Won't surprise me now that I know what I know. What would you be led by? Recorder. Gentlemen, you shall not be dismissed till we have a verdict that the court will accept, and you shall be locked up without meat, drink, fire, and tobacco. You shall not think thus to abuse the court. We will have a verdict by the help of God, or you shall starve for it. Bloody hell, they'd be locked up for that now, wouldn't they, in the Judicial Conduct Office, threatening to starve them. So the jury went upstairs. Well, no, they returned the jury back, and then they brought them back in, and then they ended up going upstairs and asking for some pen and paper. Then they came back down, and now I think he's going to send them again. Penn, my jury, who are my judges, ought not to thus be menaced. Their verdict should be free and not compelled. Well, this is he actually knows Magna Carta, and he's referred to it as well. He's referred to Magna Carta in this, so they know what they're talking about. The bench ought to wait upon them, but not for seat, but not foretell them. I do desire that justice may be done me, and that the arbitrary resolves of the bench may not be made the measure of my jury's verdict. Diverse and arbitrary courses. Stop that prating, fellow mouth. Stop that prating fellow's mouth, or put him out of the court. That's the recorder. Mayor, you have heard that he preached, that he gathered a company of tumultuous people. Well, he's actually saying the people are tumultuous now, and that they do not only disobey the martial power, but civil also. Penn, this is a great mistake. We did not make the tumult, but they that interrupted us. The jury cannot be so ignorant as to think that we met there with a design to disturb the civil peace, since first we were by force of arms kept out of our lawful house, and met as near it in the street as their soldiers would give us leave. And second, because it was no new thing, no other circumstances expressed in the indictment, but that was usual and customary with us. 'Tis very well known that we are a peaceable people, and cannot offer violence to any man. So it sounds like something's happened when they were prevented from getting into their houses or something. With soldiers, so they've ended up in the street. That's only just arose now. And they're claiming they're Englishmen. I wonder if these people were maybe immigrant, I don't know, some other religious faction, it seems like. But they've not denoted any. The court being ready to break up and willing to huddle the prisoners to their goal and the fury to their chamber, Penn spoke as follows. Penn: the agreement of 12 men is a verdict in law. I think the battery's going to go in the phone soon. I've got one more page. I'm nearly at the bottom of this page. The agreement of 12 men is a verdict in law, and soeth and truth is that and such or such. An agreement of 12 men is a verdict in law, and such a one being given by the jury. All right, Penn's saying that, right, this is really important now. So Penn is saying that the agreement of 12 men is a verdict in law, and such a one being given by the jury as well. So he's differentiating between an agreement of men, 12 men, is a verdict in law, but also one being given by a jury as well. So that would suggest that the petition, or any petition through lawful process, signed is such an agreement, like we were saying with consent and the opinion of your peers. So if your peers agree and sign consent to your petition, they're agreeing on your actions in pursuit of it and so forth as reasonable or required. Equal to, if it was a court and a jury, it would just decide on their opinion and not on law of what they thought was just or reasonable or whatever, right? Which we're all meant to consent to the police. We all meant to, that's why they make legislation in law for the police, because everyone agrees that, well, we don't mind the police doing these certain things that everyone else is, no one else can do them. They're illegal, but we'll consent to the police being able to do it because they're upholding the law. That's merely on, if we all decided we weren't going to let them do that anymore, then we would, seek to get the law changed. So this dialogue from this case, which is a lot lesser known than the words in the plaque, Penn, he proclaims, the agreement of 12 men is a verdict in law, and such one being given by the jury. I require the clerk of the peace to record it, as he will answer it at his peril. And if the judge bring in an other verdict contrary to this, I affirm they are prejudged men in law. And looking upon the jury, said, you are Englishmen. Mind your privilege. Give not away your right. So Penn's quite well versed in, I think, in Magna Carta and the Tumultuous Petitioning Act, and probably generally. I don't know about this Petition of Right as well, which is a reaffirmation of Magna Carta. They had the Petition of Right as well. Bush, we will never ever do it. Orator, one of the jurymen pleaded in position of body, and therefore deferred to be dismissed. One of the jurymen pleaded indisposition of body and therefore desired to be dismissed. Mayor, you are as strong as any of them. Starve them and hold your principles. Recorder, gentlemen, you must be contented with your hard fate. Let your patience overcome it, for the court is resolved to have a verdict, and that therefore you can be dismissed. Jury, we are agreed. We are agreed. We are agreed. Narrator, the court swore several persons to keep the jury all night without meat, drink, fire, or any other accommodation if they had not so much as a chamber pot they desired. So this is the last, I'm on to the last page now. It was 4 very big pages. I don't know if I'll get through this before the battery runs out on this phone. Cry. Oh, yes. The court adjourned till 7 o'clock next morning. So this is going on a few days now. Bring the fourth vulgarly called Sunday. Bring the fourth vulgarly called Sunday. Being the fourth instant vulgarly called Sunday, at which time the prisoners were brought to the bar. The court sat and the jury called to bring their verdict. Cry, oh yes, and silence in the court upon pain of imprisonment. The jury's names called over. Clerk, are you agreed upon your verdict? Jury, yes. Clerk, who shall speak for you? Jury, our foreman. Clerk, what say you? Look upon the prisoners at the bar. Is William Penn guilty of the matter whereof he stands indicted in manner and form, as aforesaid, or not guilty? Foreman, William Penn is guilty of speaking in Gracechurch Street. Mayor, to an unlawful assembly. Bush, no, my lord, we give no other verdict than what we gave last night. We have no other verdict to give. What's that? I keep getting these jury people mixed up because that italics is not written very well. You are a factitious fellow. I take a course with you. Bloodsworth. That's one of the aldermen, isn't it? I knew Mr. Bushell would not yield. Bushell, Sir Thomas, I have done according to my conscience. I have done according to my conscience. Mayor, that conscience of yours would cut my throat. Bushell, no, my lord, it never shall. Maybe the mayor's a bit worried if the king's going to get him into trouble if he doesn't prosecute these people for the tumultuous. Maybe the mayor might think that he's going to get in trouble. Really, they should have. I want to find these proceedings. What you could have been up in front of this mayor and these aldermen, actually getting approval and consent for a petition to go through. The thing about this whole affair, what is not communicated when people talk about this case generally, and that plaque on the wall, is that there was a legal procedure what you could go through to get consent of having large numbers of people at the time, a special procedure in law where you could get approval and consent in legal to pursue large numbers of people. That's the thing. But they haven't got it, and they just went and did it. But there was something going on with, they couldn't get into the houses or something, and it ended up leading to this, but they don't go into it too much. So the mayor's like, to an unlawful assembly. No, we give no other verdict than what we gave last night. We have no other verdict to give. Mayor, you are a fictitious fellow. I'll take a course with you. I think Mayor, that conscience of yours will cut my throat. No, my lord, it never shall, Mayor, but I will cut yours so soon as I can. He's on to threatening to cut their throats here, which I don't think they go over that usually when they're telling this story. This would get him straight into judicial conduct office. This in 10 seconds, he's going to go, I shall cut your throat. No, my lord, no shall. I will cut yours as so soon as I can. Recorder, he has inspired the jury. He has the spirit of divination, methinks. I feel him. I will have a positive verdict, or you shall starve for it. Penn, I desire to ask the recorder one question. Do you allow of the verdict given of William Mead? Recorder, it cannot be a verdict because you were indicted for a conspiracy, and one being found not guilty and not the other, it could not be a verdict. What's he talking about conspiracy now? Which are we going on about a tumult and disorderly solicitings, and also they were going on about riots. Someone define what a riot is. Penn, if not guilty be not a verdict, then you make of the jury and Magna Carta but a mere note of wax. Right, so Penn is actually now calling them out on Magna Carta in these proceedings. Of you got the right for a lawful process of law judged by point of law or the opinion of your peers, which is what they're giving, which doesn't have to be under point of law. It's like the opinion of their peers. So the Penn's like, yeah, it's they can do that, which he knows, and they're saying this. I would like to know if Tim Crossland has actually read this or not, and that's why he's holding a card up, Magna Carta, or if he's only just read the website's accounts of it. I'm guessing he's probably read this, or you know, but a lot of people don't seem to discuss this at all whatsoever. People don't talk about any of this stuff in here when they talk about that case. So, do you allow for the verdict given? So they wrote it down on paper. They said not guilty. Cannot be a verdict because you were indicted for a conspiracy and one being found not guilty and not the other. It could not be a verdict. If not guilty be not a verdict, then you make of the jury a Magna Carta but a mere note of wax. Mead, how is not guilty no verdict? How is it no verdict? Recorder, no, 'tis no verdict. So recorder is saying that not guilty is not a verdict now. So the recorder is actually talking a load of bollock. Penn, I affirm that the consent of a jury is a verdict in law. So he's saying the word consent of a jury is a verdict in law. It's like an opinion. And that is the word consent appears in the Tumultuous Petitioning Act, that you're getting the consent of the people who sign. It actually refers to you're not allowed to get the consent of over 20 people without going to a court. But if it's under 20, you can get their consent and proceed and even lay the petition to Parliament with the consent of the undersigned. Penn, I affirm that the consent of a jury is a verdict in law. And if William Mead be not guilty, it consequently follows that I am clear. Since you have indicted us of a conspiracy, I could not possibly conspire alone. So he's saying he's indicted them with a conspiracy now, but earlier on he was saying that they wouldn't say exactly what it was, and then they were going on about what the definition of a riot is, and then it's just a tumultuous gathering, and the jury are just saying they're speaking in public. I like to think that it would be cool to go back in time and actually speak to people like us who are, political people who are interested in politics and petitioning and the law, at least, have an interest in it and know something about it, to see what, the bill of, the right to petition means, or the Magna Carta means, or what they thought it meant. So this, to me, these are the words of a man from, from 1670. These are the recorded opinions and words of a man from 1670, appearing in a court, a man who knows something about law in his time. He knows the Magna Carta. He knows about the Tumultuous Petitioning Act. He's actually speaking to people in public. This is a fairly educated man, probably the same as anyone from Extinction Rebellion or anyone else. He knows something about his laws and rights. He's not just like a common thief or a robber or whatever. So he's saying. So this is Penn. He says, if I go back in time to 1670 and I find someone like me who has been reading law and thinks that they've got a fair understanding of it and has been engaging in political things, or at least speaking to people, right? Although I won't be found getting 300 people around me in the street. Maybe Jonathan M. Fuller. His opinion, if I could go back in time and talk to him and ask him, well, what is the law back then? We're trying to find out. He says, I affirm that the consent of a jury is a verdict in law, and if William Mead be not guilty, it consequently follows that I am clear, since you have indicted us for a conspiracy, I could not possibly conspire alone. And also, if not guilty be not a verdict, then you make of the jury a Magna Carta but a mere note of wax. So he's saying that you're taking a piss. He's saying that you're just ignoring Magna Carta. He's actually saying, look, it's like me saying to Max Hill, like, why have you just totally disregarded and ignored two complete full acts of law? Like, the Town and Country Planning Act 1991 and the Statutory Insurance 2007, Class F, with Angela Ditchfield as if it didn't exist, right? And not even, you just prosecuted her with criminal damage when it's defacement. It's not even the right charge. Even if it wasn't political, it's not criminal damage anyway. It's like you're just literally talking absolute bollocks. This is what Penn's saying. He's saying, what the fuck are you talking about? Penny's like... So Penny's like, you're actually talking bollocks. You know, he's effectively saying to this judge that, and the recorder, that, you don't know what you're talking about with the law. You're literally saying that Magna Carta, acting as if it doesn't exist or doesn't apply. So there were many passages that could not be passages. There were many passages that could not be taken, which passed between the jury and the courts. And the jury went up again, having received a fresh charge from the bench, if possible, to extort an unjust verdict. So the bench come out with a fresh charge, a different charge. Now, cry, oh yes, and silence in the courts. Court, call of the jury, which was done. Clerk, what say you? Is William Penn guilty of the matter whereof he stands? Indicted in manner, form aforesaid, or not guilty? Foreman, guilty of speaking in Gracechurch Street. Recorder, what is this to the purpose? I say I will have a verdict, and speaking to Edward Burford, said, you are a fictitious fellow. I will set a mark upon you, and whilst I have anything to do in the city, I will have an eye upon you. Mayor, have you no more wit than to be led by such pitiful fellow? I will cut his nose. It's a bit like when I used to go to the pub, and they used to have a Crown Prosecutor used to drink in there and sit at the bar by himself and drink his sorrows away. That's like having an eye upon you, We'll have a Crown Prosecutor in the pub keeping an eye upon you, Penn. It is intolerable that my jury should be thus menaced. Is this according to the fundamental laws? Are not they my proper judges by the Great Charter of England? It's Magna Carta. What hope is there of ever having justice done when juries are threatened and their verdicts rejected? I am concerned to speak and grieved to see such arbitrary proceedings. Did not the lieutenant of the Tower render one of them worse than a felon? And do you not plainly reform to condemn such for fictitious fellows? Do you not plainly, or seem to condemn such for fictitious fellows, or answer not your ends? Unhappy are those juries who are threatened to be fined and starved and ruined if they give not the verdicts contrary to their consciences. Recorder, my lord, you must take a course with that same fellow. Mayor, stop his mouth. Jailer, bring letters or fetters to take him to the ground. Penn, do your pleasure, I matter not your fetters. Recorder, till now I never understood the reason of the policy and prudence of the Spaniards in suffering the Inquisition among them, and certainly it will never be well with us till something like unto the Spanish Inquisition, be in England. Orator, the jury being required to go together to find another verdict and steadfastly refusing it, saying they could give no other verdict than what was already given, the recorder in the great passion was running off the bench with the words of his mouth, I protest it will fit here no longer to hear these things, at which the mayor, calling, stay, stay, he returned and directed himself into the jury and spoke as followeth. Recorder, gentlemen, we shall not be at this trade always with you. You will find the next sessions of Parliament there will be a law made that those that will not conform shall not have the protection of the law. Mr. Lee draw up another verdict that they may bring it in special. Lee, I cannot tell how to do it. For we ought not to be returned having all agreed and set our hands to the verdict. Well, these are members of the jury, I cannot tell how to do it. Recorder, gentlemen. So this is probably really the most significant part of all of it. So the recorder, he says, gentlemen, we shall not be at this trade always with you. You will find the next sessions of Parliament there will be a law made that those that will not conform shall not have the protection of the law. So he's threatening that he's going to the recorder is saying that he's going to make certain that the law gets changed by Parliament. That either he's I don't know how he's going to do it, whether he's going to petition them or get his pals and buddies in law to get the law changed. But he's going to have words with people in high places, and he's the recorder of the court in London. He's claiming that he's going to make sure that the law gets changed in Parliament so the jury don't have a protection in law anymore. So he's admitting that there is a protection in law and it does exist. And I would claim that was for petitioning as well already exists. Obviously, if you do the proper procedure, like if it's under 20 signed, or if you go through the consent and evaluation properly, that there is a protection in law, just not for if you do this, over 20, this numbers of people, if it's, outside of these numbers of people, that you got to comply with. So he's, the recorder's threatening that he's going to get the law changed. He's going to go about getting the law changed. So he's actively admitting in words, if he's the recorder, I can't believe this has even been recorded. Now this, if this is on a plaque in the Old Bailey on the wall to commemorate this case, although the words attributed to it are the jury's right, what is not discussed and expressed in most evaluations and research material on this is that he threatened to get the law made or changed. Well, you do that by petitioning. You get the law made and changed by petitioning either Houses of Parliament or the King through petitions, just not a tumultuous one, right? Through lawful petitioning. So he's saying that they have got a protection of the law, but he's going to see about that they get it changed so they won't have it anymore. Now, I think that even though this is in 1670, it's 1670, so 1688, so there's another 18 years. Now, that's quite a long time. It's like 9 years after the Tumultuous Petitioning Act. I've been doing my campaign for about 10 years, 9 or 10 years. It passes quite quick. I think that those exact words that recorder came out with, in this case, which is commemorated on a plaque in the Old Bailey in London, I think that the words of that recorder threatening to take the protection away and seeing about getting the law changed, I think that had an impact on the entire history of England, at least I think that if that's been commemorated in that plaque, that's even though it's 18 years before, I think that those words being recorded words in a recorded session among politicians and people in government and even obviously activists, because that William Penn and William Mead are clearly politically active people and they know the law and rights. That has got to have had some, he's threatening to take away the protection by Parliament. And what actually happens in the Bill of Rights is the opposite. They actually end up enforcing it and protecting it even more. Like the Petition of Right is also the same from Magna Carta. The Petition of Right affirms it again. So what we actually end up with is he doesn't end up taking away the protection and rights of the jury. Instead, quite the opposite happens, and they get this plaque put on the wall, and then they actually, in the 1688 Bill of Rights, they definitely get, so out of the subjects to petition the king and all commitments and prosecutions for doing so are illegal. Although the jury's already got protection, but illegal prosecutions by the king's bench, I think that, I think that is something that you could say all people participating in cases, although it says legal prosecutions by the King's Bench from matters cognisable, decidable, debatable only in Parliament. But really, I think what the jury are demonstrating when they ask for the paper and pen and they write down their verdicts on paper in like a little petition is almost like the jury verdict in a way is a petition. Their answer, their verdict being called and sworn in, and being the peers, it is a petition to the judge, or it's but their verdict, their answer by petition, really, and they can't be prosecuted for that. So, that there will be those that not will conform shall not have the protection of the law. So, although the thing is, I also think that he's referring to the Tumultuous Act, because if you conform with the Tumultuous Act, surely you get the protection of the law because it is a petition, right? But you didn't conform to the requirements, If it's under 20, you are conforming to the law and you have got protection then, maybe. And if you don't go through the consent procedures, then, So, that will put us with, the petitions committee getting, it actually published and live with your signatures. Then surely you've conformed with procedure and you get protection, surely. Although there's the peculiar, all petitions are unique in their nature because they're all pursuing different causes or cases. I think that is set out in the Illegal, Corrupt and Legal Practices Act. It makes that quite clear. Anyway, I'm not I've only got like half a page left now to do. So who's this? Who's that Leo guy? Bulford. I think that could be Lever. I think that could be the Lever guy when it says Lee. I cannot tell how to do it. We ought not to be returned, having all agreed, and set our hands to the verdict. So he's effectively saying that they've set their hands to the verdict, so they've petitioned for the verdict. Your verdict is nothing. This is the recorder speaking now. You play upon the court. I say you shall go together and bring in another verdict, or you shall starve. And I will have you carted about the city. Carted about the city. It's another Magna Carta joke from the recorder. Not a funny one, though. As in Edward III's time, foreman, we have given our verdict and all agreed to it, and if we give it another, we will be a force. It will be a force upon us to save our lives. Mayor, take them up. Officer, my lord, they will not go up. The mayor spoke to the sheriff, and he came off his seat and said, Sheriff, come, gentlemen, you must go up if you see I am commanded to make you go. Narrator, upon which the jury went up, and several sworn to keep them without any accommodation or aforesaid till they brought up their verdict. Cry, oh yes, the court adjourns till tomorrow morning at 7 o'clock. So they adjourned it again. The prisoners were remanded to Newgate, where they remained till next morning, and they were brought unto the court, which being sat, they proceeded as followeth. Cry, oh yes, silenced in the court, upon pain of imprisonment, Clerk, set William Penn and William Mead to the bar. Gentlemen of the jury, answer to your names. Theo, Edward, Bushell, John, Hammond, Henry, Mitchell, John Brightman, Charlotte, Milford, Gregory, Walker, John, Bailey, William, Lever, James, Damask, William, Blamford. Are you all agreed on your verdict? Jury, yes. Clerk, who shall speak for you? Jury, our foreman. Clerk, look upon the prisoners. What say you? Is William Penn guilty of the matter whereof he stands indicted in manner and form? Guilty or not guilty? Foreman, here is our verdict in writing and our hands subscribed. Narrator, the clerk took the page but was stopped by the recorder from reading of it, and he commanded to ask for a positive verdict. It's commanded to ask for a positive verdict. Foreman, that is our verdict. We have subscribed to it. I think they're all kind of in on this political business, the jury as well. I think that they're like making a point that if you are doing an illegal tumult, like, it's something to do with, like, did you get any signatures? How did people agree to it? And these people in the street, these 300 people, did not really agree or subscribe to William Penn and William Mead's speech in the streets. It wasn't like an official kind of like disorderly soliciting by procuring of their hands or their agreement in any way to it. So therefore, it wasn't really an official petition or official complaint, like what they would. So this is why they're making the paper out and filling it in and signing it, because that's kind of like official, isn't it? But the court is not accepting that as official when they do. So I think there's a little bit of a play going on here between them. There's more to it there's a lot more to this story. They're making a point that they've made their own little petition, and that's not a petition. They're saying, effectively, right? What they're doing is like they're saying that's not an official petition and agreement in the street with those 300 people. This is an official little petition and agreement, and then signing a bit of paper and handing it over. That's what they're doing. That's what's going on. So I'm making a point out of it. Here is our verdict writing. I'll say you. Therefore, the verdict. Here is our verdict in writing. He commanded, that is our verdict. We have subscribed to it. How say you? Is William Penn guilty or not guilty? Foreman, not. Oh, so now the foreman, he just says. So they handed the paper again. He didn't read it out. What is your verdict? They said, that is our verdict, written down on the paper. We have subscribed to it. Then the clerk again says, how say you? Is William Penn guilty or not guilty? Foreman. Then, so this is when the jury now, they just say, not guilty. So they're actually just coming out with a straight verdict now, not even like, what either the offence or not the offence. They're just like, not guilty. Clerk, how say you? Is William Mead guilty or not guilty? Foreman, again, second time, not guilty. Clerk, then hearken your verdict. You say that William Penn is not guilty in manner and form as he stands indicted. You say that William Mead is not guilty in manner and form as he stands indicted, and so you say all. Yes, we do. So that's to both of them, isn't it? So William. So they've done both William Penn and William Mead, just not guilty without anything else. Orator, the bench, being unsatisfied with the verdict, commanded that every person should distinctly answer to their names and give their verdict, which they unanimously did, say not guilty. So he asked them one by one, to the great satisfaction of the assembly. So there were more people. There was, I think, there were a lot more people in. Recorder, I am sorry, gentlemen, you have followed your own judgments and opinions rather than the good and wholesome advice which was given you. Well, that's what it says they can do in Magna Carta. God keep my life out of your hands. But for this, the court finds you 40 mark makes a man, and imprisonment till paid. At which Penn leapt up towards the bench and said, Penn, I demand my liberty, being freed by the jury. Mayor, no, you are in for your fines. Penn, fines for what? Mayor, for contempt of court. Penn, I asked if it be in accordance to the fundamental laws of England that any Englishman should be fined or amerced, but by the judgment of his peers or jury, since it expressly contradicts the 14th and 29th chapter of the Great Charter of England. So he's reading that Magna Carta like he knows it off by heart, effectively, or close enough, which say no free man ought to be amerced but by the oath of good and lawful men of the vicinage. So it was the recorder. The recorder actually was the one who's not the mayor or the alderman. The recorder comes out with like, oh, you got like, he's saying that they've fining them. The recorder's saying that the court's fining them, not the mayor, which I find that quite ridiculous, really. But that's how it went. Very peculiar times these were indeed. So Penny's well versed in all this. He's saying if it be in accordance with fundamental laws of England that any Englishman should be fined or amerced, but by the judgment of his peers or jury. So he's referring to, this is absolutely amazing, because in Magna Carta it says that it's got to be a lawful due process and by a rule of law or the judgment of your peers. It doesn't actually say jury, it says peers, but we take it for jury. Now, so Penny's actually saying, but by the judgment of his peers or jury. So I ask if it be according to the fundamental laws of England that an Englishman should be fined or amerced, but by the judgment of his peers or jury. So he's referring to the fundamental laws of Magna Carta that it can effectively be, if it wants, by the judgment of peers or jury. I like how he's actually saying peers or jury here. And I think that is really, really relevant to like the people who support a cause, the consent of the undersigned of the petition as well, being equal to the jury or the same, but because it's a lawful due process. As long as, if he'd have followed, you see, if he would have been in this courtroom with a petition of 20 people asking for consent and approval to then go and take it to more people, then I think that he would have the consent and the special protection of law, which they've already got, and for the whole thing, which is like assisting offenders, effectively, which is where I think that it's from, you know. And since it expressly contradicts the 14th and 29th chapter of the Great Charter of England, which say no free man ought to be amerced but by the oath of good and lawful men. So they're actually, what Penn's doing in the language of someone in 1670, he's a man in 1670 who is engaging in all this. He's in these political circles, at least anyway, and he knows all about the acts of law relevant to to a significant level, a noteworthy level, is reeling it off. He's coming out with it. He can recite it, and also he can cite Sir Coke as well. He can even give citations to well-known persons who've talked about the subject as well. This is not just some like random case, and he also, in 1670, someone who knows about law believes that, or it's understood at the time, that by the oath of good and lawful men of the vicinage, so no free man ought to be immersed but by the oath. So it's actually, they're making an oath when the jury is sworn in and they give a verdict and write it down on paper. They've taken an oath. Good and lawful men of the vicinage. So take him away, take him out of the court. Penn, I can never urge the fundamental laws of England, but you cry, take him away. But it is no wonder, since the Spanish Inquisition have a great place in the recorder's heart. They're comparing them to the Spanish Inquisition. God Almighty, who is just, will judge you all for these things. Orator, they hailed the prisoners into the bail dock, and from there sent them to Newgate for non-payment of their fines. I think if they'd have paid the fines, they wouldn't have been sent. They wouldn't have been sent to Newgate if they'd have paid the fines. They bailed the prisoners into the bail dock, and from there sent them to Newgate for non-payment of their fines, and so were the jury. So if they'd have paid money, I think they'd have. But the jury were afterwards discharged upon habeas corpus returnable in the common pleas, where their commitment was adjudged illegal. So it's saying the commitment. So it's actually saying that these proceedings resulted in a commitment. The order made their fines, the charge. It was a commitment. So all prosecutions and commitments for doing so are illegal. So it definitely does mean orders by court in the Bill of Rights, commitments. It's not just like some loose thing. It's actually a prosecution and an order. A prosecution being brought and a charge being made for petitioning. So it got returned, discharged. They were afterwards discharged upon habeas corpus. So they used habeas corpus and returned in common pleas. I don't know if that common pleas where this wasn't common pleas, was adjudged illegal. And then that's where the whole plaque came from. So that's it, basically. That's the whole story. The wording on it, where the commitment was adjudged illegal. So the language they're using in this is, I think that it gets diluted down severely from that whole Old Bailey plaque and this the right of the jurors. There's so much more in this. There's a gentleman. We shall not be at this trade always with you. You will find the next sessions of Parliament there will be a law made that those that will not conform shall not have the protection of the law. I wonder if the police chief likes this and he's read it and he thinks that, maybe I get loads of people speeding, and if you not conform to the law, you shall never even be on a jury, get a chance to decide who's broken the law or not. You never have protection on the law from speed cameras. Says from the police chief who's racing around all day, you know. So yeah, Tumultuous Petitioning Act. I don't think that the William Penn and William Mead case is often referred to as a tumultuous act charge. It's just referred to as this. People know it for the fact that it is the right of the jurors to make a return a verdict on their conscience, which is their opinion. So much more in this case, like lots of stuff on Magna Carta in it, and what does a lot of the dialogue they're going through, arguing what constitutes a tumult and what doesn't. You know, what constitutes a riot, and whether even soliciting any public agreement to anything. So I cannot. It's a really good case to study, but then again, so is that Henry Burton and John Baswick case.